capacity before, but nice to see you officially in this capacity. How long ago was it that it was announced? And how 6-month interval?
I've been on the front bench since March. I think it's been 6 months or so.
Yes. Anyway, congratulations.
And it's always a pleasure to be able to do things in the traditional and formal way. The first thing I think I should deal with is the anonymity applications. They are made by learned friends and clients. As I understand it, they extend not only to the respondents themselves, but also to the witnesses. Perhaps I should just say, as far as we are concerned on this side, we have no objection to those. But I don't know if you'd like to hear learned friend.
Well, I can't believe this was at all controversial. I will be frank. I've been focusing on the substance. I saw there was such an application, but I didn't focus on it. It is. You may be able to educate me. I think I said in an earlier judgment there's no automatic rule that victims of trafficking be anonymized. That may not be entirely true because there is something in ECHR about respecting their privacy which may translate into an anonymity. But certainly it is usual in this law to be anonymized, and unless my ladies have any view about it, there's no problem about them. But what's the point about the witnesses?
I don't know. Can I say, I also hadn't been aware of this until I arrived in the courtroom today. But I'm told we have no objection to the application.
Yes, no, there has been an exchange of emails about it. Yes, Mr. Butler, what's the point about the witnesses? I can't believe it's difficult, but we ought to know.
All of the witnesses are confirmed victims of human trafficking. And
when you say witnesses, I mean, don't name them. The only witness whose evidence we're concerned with, possibly, is that of the Secretary of State.
I doubt that on this appeal, the court is going to look at the witness statements given by other victims. They were addressed below, and Mr. Justice Kerr did have regard to them. Could I just explain why, in my submission, this isn't a matter for the court's discretion, but is an automatic anonymity situation?
Automatic for witnesses?
Automatic for anybody who is a victim of human trafficking. And they are.
Well, it'd be useful to know. As I say, I don't necessarily mean to be, but for my education, Mr. Butler.
Well, my lord addressed it in the case of ZV, paragraph 11. We don't have copies. It's section 1 of the Sexual Offences Amendment Act 1992.
Yes.
And section 1, subsection 1, provides that where an allegation is to be made, only an allegation, there's an offence to which the Act applies has been committed against the person, then they are the subject of a lifelong anonymity provision.
But trafficking need not involve a sexual offence.
But section 2 of the Act, which defines the offences to which it applies, now lists section 2 of the Modern Slavery Act, which is any offence of human trafficking.
So even if there was no sexual element at all, it was to work in a cannabis farm or something.
Now, as it happens, I think that all of the witnesses in this case were, unfortunately, victims of sex trafficking. So the distinction may not matter, but on my reading of the Act, it applies to all instances of human trafficking.
Thank you. Well, that's interesting. In the unlikely event it were controversial, we might need to look at those provisions. It is slightly surprising when there isn't a sexual element, but you're telling me that's how it reads, and so be it.
Yes.
But I don't think we need to spend time on it now. So you are actually asking us, although it's not in practice going to arise, to anonymise the names of any of the witnesses were they to be referred to.
Precisely.
And in the criminal division, what we do is to put a warning at the top of any judgment saying that this is a case to which the provisions of the Sexual Offences Amendment Act apply, so that no matter relating to any person who might be a victim of such an offence can be identified throughout that person's lifetime.
Well, that would certainly be very helpful.
That's not the practice up to now, but at my lady's prompting, that's what you're suggesting we do.
Yes.
Well, we'll think about that.
My lord effectively did that in ZV by at least citing the sexual.
Yes, but we didn't have a notice on the top. Well, we may have to give that some thought. But is there a terms of an order that we're being asked to?
Well, an application notice was filed.
I see.
On the 11th of October with a draft order appended.
let's not spend any more time on this now. I'm sure we have that with our papers. I will look at it over the short adjournment, unless there's any problem with the detailed wording. We'll make the order.
I'm very grateful. Thank you.
Lord, if there's a more general point of practice, I think the Supreme Court's practice is also to have a warning at the top of the title page if there's an anonymity order in force.
Well, we don't do that in routine immigration cases. We just anonymise them.
Yes, I'm aware of that. But if outside the confines of the case there is some discussion about that, that's another data point.
No, thank you. Well, that's been useful. That's food for thought about our practice. But we'll leave it for the moment. Thank you very much.
Lord and ladies, on housekeeping, can I just check that we're all working from the same bundles? There should be a core bundle. And then 2 supplementary bundles. The second one has quite recently been added to, but we can work out where we've got to if we actually need to get down to the very bottom of it. And then there's an authorities volume, which is actually physically probably in 2 volumes. The index suggests that the split should be at tab 25. That says tab 25 should be the first tab of the new volume. I found that it actually made them slightly unequal and unwieldy to work with, but that's what the...
Unless either of my ladies has altered them, I think with us, volume 2 starts with tab 26.
Great. And I should also just say about timetable. My friend and I have briefly discussed this, and the plan is that, all being well, I should finish, I hope, around 3 o'clock this afternoon. Learned friend will then have the remainder of the afternoon and tomorrow morning until about midday, which would give me enough time for a reply.
Well, that sounds very sensible. Can I just mention one point? I certainly find it helpful. Maybe once one gets into the details, it won't be necessary to have a copy of the 1999 Act, especially Section 95, the provisions about asylum support, which weren't in the bundle. In fact, all 3 of us now have that section and also have that section, so no need for you to provide them, but you may need to have them unless you've got them.
Well, we can.
I'm just warning you that it's a section which it seems to me might possibly be relevant.
Yes. Well, I'm grateful for that, and we will make sure that we have access to that as we go along. Then the appeal. There are 2 fairly confined grounds, but as a matter of generality, I should introduce it by saying this. It starts from the premise that there was unjustified direct discrimination. And that arises because the Secretary of State is paying a group of victims of trafficking. Can I say, just so that we have this noted at the outset, we call them these Group 3 victims, more money by way of financial support than the Secretary of State pays to the group of victims of trafficking of which the respondents are part, and we have called them Group 2 to identify.
More money. Well, I've noted you down as saying because we, let's say the Secretary of State, are paying more money by way of financial support to Group 3 than to Group 2.
That's right. And that is because of a fault in the Secretary of State.
Sorry to... When you say by way of financial support, are you including in that mainstream benefits?
No, this is financial support.
Right. Okay. Well,
for trafficking, for victims of trafficking. Yes.
Keep going, Andy.
Yes, because mainstream benefits are not paid by the Home Office; they're paid by the DWP, and this is one of the problems or one of the things that has given rise to the problem.
If they weren't in receipt of mainstream benefits, they wouldn't be paid more. You're paying the same. It's that they're being paid twice
That's
because
right.
mainstream benefits cover the same ground.
Exactly so. Because I should say there's also the Group 1 victims. I'll come on to describe what they are. The Group 1 victims who they are not in receipt of asylum support, but they're not entitled to mainstream benefits. They're also paid the same. So the Secretary of State does pay the same money to each of these 3 groups.
You see, that's why I thought you must be referring to mainstream benefits, because in terms of financial support, I thought they all dropped the same by way of VOT payments, except for those who got asylum support, which in money terms is the same, although Mr. Butler has a point about the character of the payments. Am I not right?
Well, that's exactly right, because philosophically you could look at this in two ways. There are two different departments, each paying the Group 3 victims money for the same thing. As a judge said, you wouldn't expect the state to pay twice for the same need. I suppose it's a matter of semantics, whether or analysis, whether it's the Secretary of State that's overpaying, or whether it's the DWP that's overpaying.
Yeah. Well, we're not asking you to anticipate your submissions now. Yes. Speaking for myself, I had great difficulty getting to the bottom of what was actually happening. Nowhere was it really clearly set out what these people were. Sorry, these people. I don't mean that rudely. What these various categories of victims of trafficking were getting. So at some point, I'd like you just to talk us through that, make quite sure we got firm ground beneath our feet.
Absolutely.
That's why I wanted to look at the 1999 Act.
Yes, indeed. I will do that. I've prepared to do that, and I hope that section will
I'll
be
let you
helpful.
get on with your intro.
Yes, but I should say, right at the outset, we acknowledge this is because of a fault in the Secretary of State's policy. And it amounts to Group 3 victims getting an unintended windfall. And
you say fault in the Secretary of State. I'm sorry to keep interrupting you, but surely, strictly speaking, if we've answered it correctly, it's in the policy of the Secretary of State for Work and Pensions. Because I thought from Ms. Tam's statement, what she was saying was that victim of trafficking benefits should have been deducted in the calculation of mainstream benefits.
What appears to have happened, and I have to say it was really quite difficult for us to try and find out. What appears to have happened is this: that prior to universal credit, if you got other sources of income, like, for example, asylum support, then your mainstream benefits would be reduced by the amount that you got from elsewhere. So if you were a Group 3 victim on legacy benefits, and you would get paid, say, I'm plucking a figure out of the air, £100 a week from benefits, but actually you're getting £65 a week from asylum support, then your mainstream benefits would be reduced by that. And that's how the double payment is eliminated.
Yes.
But what happened when there was a change to universal credit was that the DWP rewrote its rules. So instead of taking into account all other sources of income and reducing the benefits, the universal credit rules listed specific things which would be set off, or which would reduce the amount of universal credit. But asylum support was not one of them.
Well, exactly. That's what I was putting to you. So it's not, strictly speaking, a fault in your Secretary of State's policy. It's a fault in the Secretary of State for Work and Pensions policy.
Well,
her legislating.
Yes. Well, I don't. I don't hold a brief for the DWP.
No, but I wasn't just being pernickety. I'm trying to understand where the problem has arisen.
Well,
your explanation suggests that the deep down problem, as you seek to present it to the court, is that asylum and victim of trafficking benefits are not deducted. Well, asylum doesn't arise, but victim of trafficking benefits are not deducted in the calculation of universal credit. And that is part of the universal credit architecture, not part of the victim of trafficking support architecture.
It's certainly
not right?
Yes, it's certainly part of the universal credit architecture. What I don't think I can properly do is to say that it's the DWP's fault, because I'm not instructed by the DWP. I don't know what they'd say.
Yeah, I'm not worried about fault in a moral sense. I'm just trying to see where in the structure the problem would have to be corrected.
Well, it could be corrected in one of two ways. It could be corrected by the DWP if they listed trafficking support as something that should be deducted, because then mainstream benefits would be reduced and the double payment would be eliminated. Or alternatively, it could be fixed by the Home Secretary, the Home Office, by saying that if you're on universal credit and you're getting your essential living needs that way, then the Home Office doesn't need to pay you for essential living needs. It could be done one way or the other. And these are actually some of the factors that led us to describe the whole setup to the judge as squidgy jelly. There are so many parts, and different departments are responsible for different parts of it. But once you start pushing at one part of this, you'll find unexpectedly that something falls out of the other end. And that is actually, in practical and legal terms, exactly the source of the problem. The consequences are what one has to deal with in this case. There are two points that I should ask the court, please, to note. The first is that the payments in issue in this case are the payments in respect of the victim's dependent children. And this case has always only been about that. And the second is that the children themselves are not victims of trafficking. They are simply dependent children. If they were victims themselves, they would be cared for by local authorities, and there's a whole different system relating to that. So that, I hope, identifies exactly what the case is about.
Yes. Can I just put down a marker that at one or 2 points I've wondered whether, if the logic of Mr. Butler's position was right, it would go beyond payments for dependent children. But I do see that it's always been claimed only about that.
Yes. Well, can I say, I might as well address this at the outset because it is a point, it's a point he raises. It's a point learned friend raises in his skeleton argument. He says that if you're an adult victim of trafficking, then if you're an asylum seeker, you get a total of £65. That's £65. That's £39.60, using the figures that the judge was using. £39.60 for essential living needs from asylum support, and £25.40 from trafficking support as a top-up for your trafficking. So total of that. But if you're on mainstream benefits, then you get your mainstream benefits, which will pay you your essential living needs and more, and then you get the full £65. So there is a similar issue that appears to arise there, and my lord is exactly right about that. But this case itself is only concerned with the dependent children payments.
You said you're making 2 points. You're coming to the second.
No, that was the the 2 points were that we're dealing only with the payments to dependent children, and the second is that dependent children are not victims of trafficking themselves. Fine.
So that's the 3960.
Yes, the 3960 is the asylum support amount for the dependent child. Yes. As the court would have seen, there are basically two parts to our appeal. The first concerns the judge's decision that having found the direct discrimination, the unjustified direct discrimination, and made a declaration to that effect, he went on to order that we pay damages to the respondents, both pecuniary and non-pecuniary. And in a nutshell, we say that was wrong because the amount that we paid to people in the respondent's position was it is both rational, the judge found that, and, except for this argument, lawful. So they have lost nothing. And the effect of the judge's order is that the unintended windfall, again, that's a finding of fact by him, that we are in effect paying to the Group 3 victims must now be paid to all the Group 2 victims. And indeed, you couldn't separate that. You'd have to pay them to Group 1 victims as well. And we say that if you look at the case law and the principles on the payment of damages for Article 14 breaches, that is not something that is necessary. You don't extend unjustified anomalies and windfalls wider than they already are. So that's ground one. The other part of the appeal concerns indirect discrimination, because the judge found that there was also indirect discrimination. The analysis of that has been really quite obscure throughout. Learned Friend, I think, had two different goes at it in preparation for the hearing below, and then the judge came up with a different one, which Learned Friend then accepted, and now there are two more, I think, reversion to one. So that is an aspect of the case which we say the conclusion was simply wrong. There was no indirect discrimination involved here. This was always a case of direct discrimination or nothing. And it's actually quite a simple answer. There was direct discrimination, and really the indirect discrimination part of the case should be put to one side.
What would, in practical terms, what in practical terms is added by the indirect discrimination claim?
We are concerned on a litigation basis with one thing. The indirect discrimination which the judge found was on the ground of sex. And we are concerned that that may sound in a higher level of damages, if we have to pay damages, than the direct discrimination on the basis of asylum support. So that's why we have an interest in this, but I accept it's a relatively small one. However, when the court granted us permission to appeal, we had also made the point that actually, if the analysis in the judgment is wrong, it might be better for it to be fixed rather than it continue to cause trouble. We say that actually there is authority, I'll come to this, that if there is direct discrimination, the same conduct cannot be indirect discrimination. That ought actually to put an end to all of this. But we also say as a backup to that, even if there was some form of indirect discrimination, the fact that we are trying to put this right by the means, but by completely replacing this scheme with something that is going to be tailored to individuals, would justify the indirect discrimination, even if, as the judge found, it didn't justify the direct discrimination. So that's grounds 2 and 3, but it's really one part of the case. Learned Friend's respondents' notices raise 4 points. Both of the respondents, first of all, seek to re-argue the facts found by the judge about the nature of the overpayment. And that's one of the reasons why I will come to deal with the facts in some detail. They also both seek to argue that the state is, in any event, required by ECHR to cover the costs of childcare while victims of trafficking are attending appointments related to their recovery from trafficking. And then MD alone seeks to pursue the indirect discrimination arguments on 2 bases, one about lone parents compared to co-parents, and the other a Thlemenos positive discrimination argument. I'll come to touch on those briefly, but I think there may be quite a lot that I can only say in reply. So having introduced that, can I then turn to the facts and the background and how this has all come about? You have the judge's judgment, and you've got both sides' skeleton arguments. I'm not going to just slavishly go through that. But looking at the 2 skeleton arguments where they deal with the facts, one might think that they were living in parallel universes because they describe the situation in such different ways. One thing which I would ask the court to do very carefully whenever looking at the respondent's skeleton argument is to notice that there's a technique which Learned Friend has used, quite effective in many cases, of giving certain concepts names or terms, and in fact identifying them with capitalization. So the 2 in this case are exclusionary rule and dependent child trafficking support. These are not terms of art. These just come purely from the respondent's side. And what I would ask the court to do is to be very careful when looking at these, because the judge, having found the facts that he did, using those terms is apt to mislead by misdescription. What I would ask the court to do instead is to make sure that the source material is understood and the actual way in which the system works is understood. We set out in our skeleton argument, I'm not going to ask you to turn it up now, but at paragraphs 2.1 to 2.6, a sort of framework of what this is. That starts in the core bundle at page 18. Number 1, the UK has support obligations under ECAT. The relevant parts of that have not been incorporated into domestic law via legislation. There's a whole other series of litigation that may touch on that aspect of it. But there is statutory guidance that's been issued.
Sorry, can we just pause there? I thought perhaps wrongly, that rather vexed issue, which, as you say, is coming up in a case in district court in February, and which has in the meantime been the subject of a decision by Mr. Justice Linden, was thought to arise in this litigation in connection with one of the respondents' notice points. I'm perfectly happy if it didn't, but is it in arise or not?
Well, I think I will have to see how my learned friend.
Yes, I see. Okay.
Yes, because there is potentially a point there, but we will.
I know that the court has had correspondence from parties to other litigation saying, "Oh, look, this point which we thought was going to come up in EG, where I think you're instructed, aren't you?"
Yes.
Yes. Is actually now going to come up in MD, but I didn't know any different, so I assumed it would. But I found it a little bit difficult to see where it was in the skeleton, so it's on the edges.
Yes. Well, I mean, we have sort of prophylactically cited the Supreme Court case.
Exactly. Let's see how we go on that. But I just wanted to.
But for present purposes, we are concerned with the policy and what the policy provides. So there is a policy in the form of statutory guides. That's to say, guidance issued under a statutory obligation. There's also what we say the practical implementation via contract with the Salvation Army. We do draw attention to the fact that the circumstances of victims of trafficking do cover a very wide variety of people. So that's how you get the three groups. The group one, as we've described it, are victims of trafficking who have no recourse to mainstream benefits, and they will have no permission to be here. They don't have benefits, and they are not claiming asylum. In a sense, they're the purest form of victim of trafficking.
Why wouldn't they be claiming asylum?
Well, some of them may not wish to stay here for any length of time. So some victims of trafficking may want to go home, and so they may not be asking to stay here on any basis. But we still.
Sorry, just a refinement of that. Useful to understand this. That literally, if they want to go home, they can get on a plane tomorrow, assuming they can find the money. But it's more subtle than that, isn't it? It's people who don't want to stay here permanently, but have to stay for a bit, maybe actually the last year because of travel difficulties of COVID. But even apart from that, they may need a spell of recovery before they're ready to go home. But they don't want to say or can't say that in their home country they will continue to be at risk of trafficking or Article 3. That all depend on the kind of trafficking it was and the particular circumstances.
Or I suppose we may need them to stay here in order to prosecute criminal charges.
Yes, well, we may do, although if that is necessary, then it may be that they would be granted a period of leave to remain, and then they'll be in a different category altogether. But this group does exist, people who are not claiming asylum, but who are here for whatever length of time, and we are obliged to support them during that period.
And do you have any idea how many people we're talking about in these groups?
I don't think I can give reliable figures.
That's
overall,
fine.
But the total cohort is in the order of thousands, and they'll be split as between the three groups I described. One of the things, of course, is that this case is concerned only with those victims who have dependent children, who will be a subset of each of those. I don't think I can be prescriptive. What Learned Friend has done is to identify evidence from which he says that, I think in the order of a few hundred asylum seekers with dependent children. So that part of group 2 is of that order.
Thank you. I took you out of your course. You're telling us
Not
about group
at all, because
Group 1, as you say, is the purest form of because no element of no other source of benefits.
No other source of benefits, and so they are supported through the trafficking support system. Full stop. Then there's group 2, who have claimed asylum and who receive asylum support. The asylum support is, of course, a statutory right. The statute provides for it. And I don't know if that is the point, the reason why my Lord mentioned Section 95.
Well, it's part of
that's,
it, yes.
that's one of the statutory provisions for support for asylum seekers. And so if somebody falls within that and they've claimed asylum support, then the Home Secretary is obliged to pay asylum support.
Well, if you look at Section 95, it's discretionary. Well, it's 2 points. A, he's got to believe there's a risk of destitution.
Yes.
And secondly, theoretically, it's discretionary. I'm sure anyone would say in the real world, if there is a risk of destitution, it's hard to see there could be any proper grounds for not exercising discretion. But it's framed as a discretion, isn't it?
The reception directive change. The reception directive change.
Ah.
Yes. Whatever the...
I overheard that,
Yes,
but I think that just illustrates that if we're going to understand this, we need just to be able to set it out accurately in the judgment, quite apart from anything else.
Yes.
We'd like, therefore, to see the relevant bits of the reception directive and be assured that it's part of retained EU law, which I'm assuming we're going to be told it is.
Yes, you have to check that. But the fundamental point for the purposes of this case is that if you're claiming asylum support, generally you'll have an entitlement to it, and if the Secretary of State is paying it, then there will be an entitlement to that. And of course, we all know that asylum support is paid for your essential living needs. It's to avert destitution, and that's the extent of it.
Yes, and the reason I particularly wanted the section is that phrase, essential living needs, is in Section 95.3. It's part of the definition of destitution. Yeah.
And then there is Group 3, who are the victims of trafficking who are able to access mainstream benefits. Typically, they have a right to live here. That means they're entitled to work as well.
Yes, can we just be precise? British citizens, obviously.
Yes.
They are, and one's always been told not to overlook the fact that a proportion of victims of trafficking are British citizens.
Yes.
No idea what. It's small but real. Is that
Yes,
right?
That's right.
And if you are on ILR, if you're settled here, indefinitely to remain, you're presumably entitled to mainstream benefits.
Yes.
What about if you have some other form of?
There will be some forms of leave that will allow you to work, and other forms of leave.
No, sorry, I was on benefits at the moment. Well, let's just take universal credit. It may not be the only relevant benefit. You can get universal credit if you're a British citizen. You can get universal credit presumably if you're settled here. Can you get universal credit if you have leave to remain but not ILR?
Well, as we understand it, if your leave allows you to access benefits, then you will have access to universal credit.
What determines whether your leave does allow you to access
the
benefits?
conditions of the leave? Because some leave it prohibits you from recourse to public funds, but other forms of leave do not.
So that's the way it works. So the definition in universal credit itself doesn't contain any limitation to British citizens or people settled here, but you may be excluded as a condition of your leave to remain from claiming those benefits.
We can check.
Could we have a short note on
Yes.
that? Again, I appreciate it doesn't go to the heart of this, but we want to be accurate.
Yes, of course.
Thank you. You understand what the point is. Those behind you do. Yeah.
Yes, but we'll work on that. But the point of identifying the three groups is that you can see that, first of all, the breadth of the cohort of victims generally, but also that there is inevitably going to be an interaction between trafficking support and asylum support for Group 2, and between trafficking support and mainstream benefits for anybody in Group 3 who's claiming benefits. And so if you adjust any part of a system where it's going to cross different systems, indeed different departments, you're liable to produce knock-on effects, and hence the squidgy jelly. So that's the general outline of the structure of the cohort and the different parts of it. Can I turn to ask the court to look at the policy itself and to see how it deals with this and where the fault arises? This is in Supplementary Bundle 2, and I'm going to ask the court please to go to page 172. The reason for that is that this is the couple of relevant pages from the version of the policy that was in force at the time of the decisions under challenge.
Yes, I was going to ask for your help on that.
Yes.
So, although rather annoyingly, but my fault, no doubt, I've marked up the version that's in the authorities bundle, that postdates what, there's no difference of substance, but the references are different.
The references are different, and I think paragraph numbers will be different. There's also one other difference that's happened there, which is that the amount of £39.60 has been increased to £39.63. Now, you may think that's trivial. The reason for that is because the figure in the trafficking support policy tracks the amount paid for essential living needs in the asylum support system. It's the same figure. And it's one of the ways in which you can see that where the policy refers, and I'm going to go back to 3960, it's a reference to the amount for essential living needs. That's where it comes from.
What again will be helpful while we're asking for notes is just a very short note. One, identifying the periods covered by the claim. As I understand it, the periods covered by each claim will be slightly different for each claimant, but broadly the same, conceptually the same. One, when they first became entitled to asylum support. And secondly, when they got refugee status, which in both cases I think was after the start of the proceedings. Because once you actually become a refugee, then presumably you're entitled to mainstream benefits. Anyway, you get out of this system.
Exactly. Yes.
And then what I would like for each is just to identify during that period which is the governing version of the policy. Maybe the same one throughout. And what are the numbers going during that period?
Lord, yes.
May sound very tricky, but for example, if you cross-refer to the claim form,
yes,
all the figures look different.
yes.
So it's a boring task for somebody, but to make sure we don't muddle ourselves.
Yes, what we'll do is try and extract that into probably a table that will make clear where all the chronological changes are.
That would be very helpful.
But can I just say, Lord said when you're granted asylum, you're taken outside the system. That, with respect, is not quite right, because you remain a victim of trafficking.
Yes.
One of the things that does happen, though, when you're granted leave, as these respondents were, is that you move from Group 2 to Group 3.
Yes.
Just by that fact.
Yes, so the crucial point is that you become entitled to mainstream benefits.
That's right, yes. The section, on page 172 near the bottom of the page, there's a section of financial support, and these are the few paragraphs that are really at the core of this. 1535, potential victims and victims of modern slavery who've received a positive reasonable grounds decision and are in VCC accommodation or outreach support will be paid financial support, and the payment will continue for as long as they're assessed to have a recovery need, etc. Financial support is intended to meet the potential victim's essential living needs during this period, so that's one of the aspects, and assist with their social, psychological, and physical recovery. The current rates are, and the ones I asked the court please to note are, £65 per week for those in self-catered VCC accommodation. And then at the top of the next page, the third bullet point, subject to 1538 below, child dependents will also receive financial support, £39.60 per week for each child dependent. And there's a small uplift for very young children, and then there are other benefits as well in the rest of that paragraph. And at 1537 and 38, there are two paragraphs dealing with the interaction with the asylum support system. The payment rates will be adjusted if the potential victim or victim is also an asylum seeker or failed asylum seeker receiving financial support under sections 95, 98 or 4 of the 1999 Act. I just pause there, given my Lord's question earlier. Section 95 is probably the main provision, but those are the three sections under which asylum support.
98 is some sort of temporary support, and Section 4 is accommodation.
Section 4 is failed asylum seekers.
Oh, right.
Yes.
Right. And sorry, just while we're there, the heading says financial support for potential victims, but that's inaccurate, isn't it? Because the text makes it clear it is also established victims. You have to be careful with these documents, they're rather loosely drafted.
I think what happens is that people pay attention to the redrafting of the text, but not necessarily to the headings.
It doesn't matter, but it's
perfectly clear from the text. Yes. In these circumstances, the individual will receive £65 a week. So that's the same figure as at the very bottom of the previous page. £65 a week, made up of payments from asylum support and a further payment from the VCC to take the total payment to £65 a week. So typically, that will be, under these figures, £39.60 from asylum support. And then a top-up from the VCC to get to 65.
Now, where do we find that there was a figure of £39.60 for asylum support?
That will have been prescribed by the relevant asylum support legislation. There was no.
We better see that as well.
Yes, we
I think it's the Asylum Support Regulations 2000, and I think they are rather clumsily, every time the rate goes up, they have to be amended. But if we could have the version that was in force in the relevant period or period, so we can see exactly where the figures come from.
Well, yes, we would dig those out. And then at 1538, victims who are receiving asylum support will not receive any financial support through the VCC in respect of any dependents or pregnancy payments, as these will be met through the asylum support system. So I said a few minutes ago that one had to be careful about the description that Learned Friend seeks to put on this of exclusionary rule. When you look at the text, it is nothing like an exclusionary rule. What this is doing is saying that the amounts come from two different sources. Where you're a Group 2 victim, let's say you're an asylum seeker, the total that you get from the trafficking support is the same whether you're Group 2 or Group 1, which is the pure form of trafficking support. This is simply a provision that allocates the channel, recognises the channels through which this is coming. And in relation to those who are receiving asylum support, one might think it would be necessary to do this because asylum support is a legal entitlement through the statutory materials. So it's got to come through that. But this is how the Group 2 victim is paid the same as the Group 1 victim. Now the question arises as to what these payments are for. I've made reference to 3960 being aligned with the asylum support rate, but there is actually authority that describes the purpose of the two components here, 3960 and 2540. And that is Mr. Justice Mostyn's decision in K. Can I please ask the court to look at Authorities Volume 1, Tab 19. This is page 596, or actually, if everyone's working from paper bundles, I think. The issue that gave rise to this case was that the Secretary of State changed what was being paid to asylum seeker victims by reducing it simply to the asylum support level from what it had previously been. and there was a complaint made about that. The relevant part of this claim, in fact, perhaps I should just draw attention to the second half of the head note description of the facts. So you can see it set out very concisely. The Secretary of State purported unilaterally to change the contract terms so as, in effect, to reduce the amount due to administrative subsistence payments from £65 to £37.75, which was then the figure for asylum support. And so the complaint was made about that. And the decision, the relevant part of the decision, is that which concerns holding 2. You see at the bottom of the page, subsistence was a very nuanced concept capable of different meanings in different contexts. What I'll show you in a moment is that Mr. Justice Mostyn thought that subsistence for the purposes of asylum seeking was different from subsistence for the purposes of trafficking. You can see the Secretary of State's argument set out on page 20, paragraph 24, bundle page 601. Where the Secretary of State argued that the decision was lawful and rational because the directive covering asylum seekers, laying down minimum standards for the reception of asylum seekers, provides that member states shall make provisions on reception conditions to ensure a standard of living adequate for the health of applicants and capable of ensuring their subsistence. Those last few words emphasised. This, he argued, is in substance the same as a directive on trafficking, which provided at Article 11.5 that the assistance and support measures shall include at least standards of living capable of ensuring victims' subsistence. And then at paragraph 25 over the page, if subsistence is a criterion in each directive, he argues, how can it be other than lawful for asylum seekers generally and asylum seekers who happen to be victims of trafficking to be paid the same? So there you see the argument. The answer from Mr. Justice Mostyn is that subsistence, when used in these directives, is a heavily nuanced concept capable of different meanings. Mr. Justice Mostyn went on to cite one of the recitals from the trafficking directive, and at 27 he says this surely requires a more expansive view of subsistence than the minimum sum needed to stave off destitution. Then after linguistic analysis of different languages, at paragraph 29, Ms. Leven drew my attention to the asylum support regulations, which excludes the cost of computers and smartphones, travel, recreational items and entertainment in the assessment of essential living needs for the purposes of asylum support. But some money for these purposes is surely reasonably required by a person in the highly vulnerable and distressing position of a victim of trafficking. This has recently, in fact, been conceded by the Home Secretary. So you see that not only the two concepts of subsistence being regarded as different, but for trafficking purposes, the subsistence which the state is required to provide is the essential living needs, which asylum seekers get anyway, plus an additional amount towards these trafficking-related needs. And that is why there is the top-up payment in the current policy for asylum seeker victims.
What do you mean by the top-up payment?
It's the £25.40 extra that makes it up to £65. So £39.60 from asylum support because they're asylum seekers.
Yeah.
And that covers essential living needs. And then because victims of trafficking are entitled to more under the directive, there is a £25.40 in addition. And then they're on parity with the Group 1 victims. They get exactly the same amount.
That figure of Well, that dual payment, as you put it, as it was paid throughout the period which we're concerned in these proceedings.
Yes. So if I can ask you please to go back to the policy itself, supplementary 2, page 1.
And there was, you're obviously accepting now, you didn't at the time, Ms. Justice Mistin was right about that.
We have accepted the decision, and we've restored the position to how it was so that it's consistent with the decision in K. I think from memory, and I think we put this into the skeleton argument, that the trafficking directive is not retained in EU law, but we continue to do this because it is written into the policy.
Yes, well, you will get an authoritative view on whether it is or it isn't. I don't know how fundamental it'll turn out to be, but again, I like to feel firm ground beneath my feet.
Yes. I think the question that Your Lordship was asking before was the directive concerning asylum seekers' reception conditions.
Yes.
And that may well still be retained, but we'll get a chapter on this.
Sorry, yes, I see. Your observation, what you were just saying was about the trafficking directive.
Yes.
And that's not you're telling me that that's not retained EU law.
Yes, because I think we put something into a skeleton argument about that, which I had.
You may well have done, and I haven't picked up.
But we'll check that.
Thank
you. But be that as it may, the structure remains. It's still in place now.
Yeah.
So if I can ask you please to go back to supplementary 2, page 173, you will therefore see conclusively the significance of the £39.60 per week for each child dependent.
So sorry, I was just making a note. Where are we going now?
Sorry, supplementary 2,
yep.
Page 173. That's the policy.
Sorry, yes, do go on.
Yes, so third bullet point from the top, child dependents will also receive financial support from VCC, £39.60 per week for each child dependent, except if you're receiving it through the asylum support system, because that's where you're getting that essential living needs payment from instead. There is one more point to make about this. In theory, it is possible that you might be an asylum seeker and therefore, broadly speaking, within Group 2, but for some reason you are not actually receiving asylum support. For example, you've never applied for it, so you're not receiving it. The way that the policy works makes it quite clear.
I suppose, not destitute.
Yes,
because you have family and friends here who may be looking after you.
Yes.
Sorry, Andrew.
Yes.
You're saying your point was you could be an asylum seeker, but for various reasons, not receiving asylum support.
Might not be receiving the financial support. The way that the policy is worded means that you would get the full amount from the VCC, from the trafficking support, simply because you're not receiving the asylum support payments.
Yeah, it's about receipt, not about entitlement.
Exactly. So you're getting the same. This is all about routing and about which channel payments come from. We therefore say, in respect to the other term in Learned Friends Skeletons, which we take objection, dependent child trafficking support, which is used to support his factual argument that the £39.60 per week is not to do with essential living needs. When you trace through all of these provisions and you see where the figures come from and how they're aligned, indeed how they've changed now in step with the 3p increment, that essential living needs is what all of this is about. And the judge was entirely right to find that. And so we say that all of this is clear support for the judge's acceptance of the Secretary of State's evidence that this is what it was about. 3960 essential living needs, 2540 for trafficking support for the victim alone, but the children are only paid essential living needs. And the judge found it was rational, and subject to this argument, it was lawful. And these are conclusions which are the basis of our appeal. But they're also conclusions which we say the respondents have shown no basis for disturbing at appellate level. Now, of course, the question is, where did it all go wrong? And where it all went wrong was that the adjustment for to avoid double payment in 1537 and 1538 relates to people receiving asylum support, essential living needs from asylum support. And what it doesn't deal with is people who receive their essential living needs from mainstream benefits. And I think this really takes me back to the questions that the court was asking me at the beginning. So whose fault, or who slipped up here? And it may be that it's one of those questions which are actually incapable of an answer. It may be that each department would say, we think we did the right thing, or each department may say, oh, sorry, we didn't think about the effect on the other system for which we were not responsible. Hard
to see how legally, certainly my questions weren't aimed at finding out historically who ought to be blamed for this state of affairs. I was trying to analyse what the state of affairs was. Is it part of your case that it matters whose fault it was? No.
My case is simply this. We accept that the outcome is one that should not have happened. That is to say, that there's a group who are being paid too much by the state. We also accept that, analysed in Article 14 terms, that is unjustified direct discrimination, because there's one group that is being treated better for no good reason. But what we do say is that by a combination of two things, it is something that is adequately reflected in a declaration of a breach of Article 14. And the remedy of damages is not necessary. The two things are, nobody's being deprived of anything that they ought to have. It's just that some people are getting more. And two, it's come about because of the squidgy jelly. Something has gone wrong, but it's an interdepartmental problem. And in a nutshell, that is why we say that an award of damages is clearly not necessary. All of this is backed up by authority, to which I will now, if I may, turn under ground one. But I should say, given the importance of the facts and background, if there are any questions which the court has at this stage before we move on.
No, I think, not without some difficulty, but with your help, I feel I've got there on the facts.
I'm grateful. We have set out the argument on this in some detail in our skeleton argument, which, as I said, I'm not going to go through. We've slightly naughtily put in some quotations into the skeleton argument, which I hope will also help to identify the relevant passages. So can I perhaps relatively...
You are allowed short passages of quotations.
Yes.
Anyway, let's not argue about that. Yep.
We do point out that the Act itself, Section 8.3, uses the word necessary, and it's actually couched in terms that no award of damages should be made unless it's necessary. So there's a presumption there. The general approach to damages in human rights claims has been set out in cases such as Anufriova in the Court of Appeal, for the court to note, that's in Authorities 1, tab 8. It starts at page 178, but it's at page 207 of the bundle, paragraphs 52 to 53. I don't think I need to ask the court to turn up any of these passages at the moment, but these are dicta that reflect the fact that the purpose of the Human Rights Act claim is principally to make sure that the violation, if there is a violation, is rectified, which of course is an exercise in which we are engaged in this context. And applied to Article 14 situations, we have taken a cue from the decision of the House of Lords in Wilkinson, but that in itself, that itself refers to an ECHR case, which is probably not with. So could I please ask the court to take Authorities 2 and go to tab 37. It's the case of Van Raalte and the Netherlands. The subject matter of this case was that there was an exemption from paying contributions to a child benefit scheme for unmarried childless women, but unmarried childless men were not exempted from that. So clearly there was a difference of treatment there that needed to be looked at. On page 1301 of the bundle, paragraph 39 of the court's judgment, you'll see the passage, it's been sidelined, where the court concludes that there was a breach of Article 14. And so a violation, if you look at paragraph 45 on the middle of the next page, having rejected the government's arguments, there has been a violation of Article 14. And then the question of damages arose, and that was dealt with at the bottom of that page. Now, on the face of it, you might have thought, well, here were men who had been made to pay money that it was discriminatory to ask them to pay. But what the court said, they first of all looked at compensation for pecuniary damage, and the applicant asked for pecuniary damage and non-pecuniary damage. The government stated that had there not been the difference in treatment complained of, men and women would have been equally liable to pay contributions, so that the applicant would have had to pay them in any case. In other words, the proper resolution of this would have been to eliminate the exemption for the women, so that they too had to pay contributions. And the court's conclusion at paragraph 50 was that the applicant was not entitled to retrospective exemption from contributions under the scheme, and so the claim for pecuniary damage had not been substantiated, and they also refused non-pecuniary damages. That case was then looked at by the House of Lords in Wilkinson.
Yes, it can't be said to be very fully reasoned. But,
no, I accept that, and that's why
Wilkinson helps.
The Wilkinson helps, and that's Authorities 1, tab 10. And if I can ask you, actually, please to go to paragraphs 26 to 28.
Can you say that again?
So paragraphs 26 is page 255 of the bundle in Lord Hoffman's speech. And Lord Hoffman starts by saying, general principle affording just satisfaction is to put the applicant so far as possible in a position in which he would have been if the state had complied with its obligations under the Act. In a discrimination case in which the wrongful act is treating A better than B, this involves forming a view about whether the state should have complied by treating A worse or B better. Normally one would conclude that A's treatment represented the norm and that B should have been treated better In some cases, however, it will be clear that A's treatment was an unjustifiable anomaly. Such a case is Van Raalte, which then describes. And then at 27, he says, in my opinion, the reason for the rejection of this claim is that if the state had complied with its convention obligations, it would have done what it did in 1989 and not exempted either men or women. That, of course, was the government's argument before the European Court. It follows that the applicant would have been no better off. He would still have had to pay. In the circumstances, the judgment itself was treated as being sufficient just satisfaction. And then, if you turn over the page to Lord Brown's speech, page 258 of the bundle, you will see it at 44, then, in fact, this is really the whole of the speech from 44 onwards. He makes a number of observations about this. At 48, can I particularly draw attention, please, to the observation that he makes that it has to be remembered when looking at damages claims that the general...
Sorry, where are we?
Sorry, paragraph 48.
I've got 48, but where's the bit about it has to be remembered?
Third line.
Sorry, yes.
Oh, I see, got it. Yep.
Yes,
Thank you. No.
It must be remembered that the general public, often the general body of taxpayers, will be footing the bill. In determining the requirements of just satisfaction, just as in the application of the Convention as a whole, regard should be had not only to the victim's rights, but also to the interests of the public generally. And then he has a section looking at various different potential scenarios, but that is clearly part of the picture, an important part of the picture, when looking at whether or not an award of damages is necessary. And then when he looks at Van Raalte at 50, after having considered classic employment cases, he says a critical feature of the Van Raalte case, which to my mind distinguishes from the employee case, is that the complainant in the Van Raalte case was in essentially the same position as all other contributors to the scheme, save only for the wrongly exempted group. Realistically, the discrimination was no more against him than against the others. There was simply no case for exempting anyone. It would have thus have been most unfair to the general body of contributors, category C, to have required them to subsidise not merely the exempted class of women, but also the equivalent men. So not only is there no call for widening the unjustified anomaly, that would come at a cost to everybody else, and that's the point that Lord Brown is making.
It may not matter, but Lord Hoffman, everyone agrees with. Lord Brown, only Lord Hope agrees with. Is that right?
Yes, but my friend says, sotto voce, that it's all obiter. These are all supporting speeches of supporting Lord Hoffman's leading speech.
Yes, but I think the point he's making that Lord Hoffman's speech itself is obiter, if you look at paragraph 24.
Yes, I mean, that's absolutely right. So it's not strictly speaking binding. It's not actually a principle that's strictly speaking binding in any event. These are observations of a kind that we will routinely look at to show what the principles
they
are.
are highly persuasive.
Highly persuasive.
Because Lord Hoffman was, as he says, doing them because he thought that the point would come up. Well, actually, is it entirely obiter? Because he says it's relevant to a point which we haven't focused on about whether he's been treated equally.
1998. Yeah.
My lady will remember all about it for other reasons, but I'm not sure it is obiter actually. What's your submission on that?
No, can I on that technical question?
Okay,
look at that
maybe
and come back to you on that.
Yes. Deal with it in reply if you like.
I think it may have mattered in Hooper. Hooper and Wilkinson were heard together and it may have mattered in Hooper.
Yes.
And I think the court dealt with it, the just satisfaction point, in Wilkinson at greater length than it did in Hooper, but it mattered in Hooper,
Yes.
but not necessarily in Wilkinson.
Yes. I've not really been, don't think either of us has really been citing these authorities for the precise ratio as a binding ratio, but these are together.
Or maybe you're selling yourself short.
Well,
it's not the most important point in the world, but I think, again, perhaps your juniors at least over lunch should look at Hooper and see whether they agree with my lady's recollection.
Of course.
It may have been important for that point. Okay.
Yes. The next case which I would ask the court to look at is Hooper, which is tab 7 in the same bundle. This was in the Court of Appeal. Can I ask the court please to go to page 172 of the bundle?
Where are we going to?
So it's tab Authorities 1, tab 7, bundle page 172.
Right. But Hooper did go to the Lords.
It did.
Yes.
Did. But the part of this judgment concerns Mr. Naylor, whose case did not go to the House of Lords.
Yes, I see.
And that's why we have we are asking to draw attention to this. In the sideline passage on page 172, the Court of Appeal turned to the question of whether the principle of just satisfaction entitles Mr. Naylor to an award for failing to receive the equivalent of widow's pension. He claims not merely in respect of past receipt, but in respect of his failure to receive payments in the future. The court then reviews the date, and then he, at 162, the court says, in 1999, Parliament had passed an act which would abolish widows' pension with effect from 9th of April 2001, but as from that date grant a bereavement allowance for a period of 52 weeks to widows and widowers alike. This reflected the fact that there had ceased to be a justification for paying pensions to widows, also reflected the fact that there was no justification for paying similar pension to widows either. The fact that widows over 45 enjoyed a right to a pension was recognised as an anomaly. Parliament decided to allow a transitional period before bringing in the new regime, and to allow those in receipt of widow's pension to continue to receive it. But it does not follow from this that there was any justification for making equivalent payments to widowers. To have done so would merely have increased the size of those to whom anomalous payments were being made. This would not have achieved any legitimate aim. And so his claim for an award failed on that ground. It's an illustration, we respectfully say, of the approach of not increasing the size of the class to which anomalous payments should be made. There's a further illustration in the case of M, which is at tab 12.
He also didn't receive a non-pecuniary award.
That's right. He simply got nothing, no damages.
Sorry, yeah.
So the next case that I'd ask you to look at, please, is the case of M, which is at tab 12. Again, this concerns one of the claimants who didn't go on to the House of Lords and then I think onwards to the Strasbourg Court. It was the case of Miss Langley, Can I ask the court, please, to go to page 299? The background to this was that there was a rule that said that you couldn't get housing benefit if you were paying rent to a former heterosexual partner. And it was an anti-abuse provision because you can see the scope for abuse if that were to be allowed. However, the anti-abuse provision didn't extend to the payment of rent to a former homosexual partner. And so this was the situation that the Court of Appeal was considering. And 75, Lord Justice Sedley said, "It is therefore germane to ask whether Miss Langley, assuming everything else in her favour, was a victim of the discriminatory effect of Regulation 7. Seems to me that in order to rank as a victim, Miss Langley must be able to show that if the regulation included same-sex couples, she would in some appreciable way be in some appreciable way better off. This she plainly cannot do. To obtain a favourable answer, it would be necessary to ask whether, if there were no such regulation at all, Miss Langley would be better off." That's a no anti-abuse provision. Naturally, she would be, but what Miss Langley would then be the victim of would not be the discriminatory element of the anti-abuse provision, but of the provision itself, to which no convention objection has been or could be taken. So, in other words, if the anti-abuse provision had not been discriminatory, it included both heterosexual and homosexual couples, ex-couples, she would have been in the same position, not entitled to housing benefit. And so when Lord Justice Sedley came on at page 302, paragraph 93, to his conclusions about her case, first, he says at paragraph 93, "For the reasons given earlier in this judgment, the problem of remedy in Miss Langley's case is hypothetical, because he'd found that she wasn't even a victim. Nevertheless, I consider that its near insolubility, save at the cost of destroying a perfectly legitimate provision, has a bearing on why there's no violation. As Mr. Sales has admitted, the outcome for Miss Langley would have been the same if there had been no difference in treatment between her and a former same-sex partner, since a single logical solution, albeit one which only the rulemaker could bring about, has always been to include same-sex couples in the anti-abuse provision. In other words, whether it is in relation to her being a victim or whether it is in relation to her securing a remedy, Miss Langley's case founders on the fact that the discrimination of which she complains has done her no harm." Now, the actual decision here was actually quite strong. She was not a victim and there'd been no violation. We don't go that far. We accept in the circumstances of these respondents' cases that there was a violation.
I don't want to tease you with why you haven't appealed against that finding, but it would just to get why is that argument not available to you in this case?
The court will have seen a reference in the judgment to an adjournment application which we made shortly before the hearing, because we weren't sure of just what had happened, and we were asking for more time to find out some of the details. Details along the lines of many of the questions I've been asked this morning. We were refused that adjournment, so we had to do the case on the basis of what we had. It's possible, I don't want to oversell this, it's possible that if we had obtained full chapter and verse on what had happened, where it had gone wrong, and in particular had more clarity then about whether it was really a DWP problem and not a Home Office problem, we might have had some ammunition with which to run a case that there was no discrimination at all, or the Secretary of State was not responsible for any discrimination.
Yeah, I say I'm not asking you to tease you. I'm just because I want to understand where your argument takes you.
But I think I have to be responsible here and say we've had the finding against us. There are things which I cannot properly seek to row back from. But the one thing that I could always, and I can now, ask the court to do is to examine very critically whether there is any necessity for an award of damages in this case. And it's an award which, once you take it through to its conclusion, basically means that the windfall must be paid to every victim of trafficking. And that's why I put the case like this, constrained as I am by the fact that there is a first instance judgment against me. Sorry, before leaving M, can I just quickly draw attention to Lord Justice Newborough's judgment, page 314 of the bundle. I'm not going to read out all of this, but it's a sideline passage, but I draw attention to the fact that at 144, he refers, as part of his concurrence with Lord Justice Sedley, to the Naylor case in Hooper. That's to say, the case that I looked at a few minutes ago. And then right at the very end of that passage, he comes round to saying that perhaps Lord Justice Sedley had been rather more elegant in just saying that Miss Langley had not been a victim, given what had happened. At any rate, the principles here are clear, and the approach is clear, and the applicability to our present situation is obvious. But I would like, I think, finally on this topic or on looking at the authorities here, to pick up that phrase about the discrimination had done her no harm. Because one of the other themes that you do find for these authorities is the call for an analogy with common law tort. The first place that I think I should ask you to look at, and perhaps the most authoritative, is Sternum, which is tab 13 in the same bundle of authorities. And if you go to bundle page 340, Lord Justice Laws made a reference to this at paragraph 15. He says, it is in my judgment worth bearing in mind that a regime in which, as here, damages for breach of a legal right or a discretionary remedy is to be contrasted with the conventional position at common law where damages for a private law wrong, tort or breach of contract are generally a matter of entitlement. The common law, however, also knows another rule, namely that damages are not generally recoverable for administrative tort, that is, for a public law wrong. Now, the distinct territory of Section 8 is marked by the fact that the defendant is a public authority and the wrong is a violation of the Convention. Depending on the facts, this territory is often a closer neighbour to our public than to our private law. That circumstance brings into focus a distinction of some significance in the search for principle. It is between cases where the violation of the Convention right has an outcome for the claimant which constitutes or is akin to a private wrong, such as trespass to the person, and cases where the violation has no such consequence. And then there's a reference to Greenfield, which is quoted. And there are two recent High Court cases which provide illustrations of how that attempt to look for an analogy with private law torts has been put into practice. These are both in Authorities Volume 2. Oh, no, sorry, that's not right. Perhaps if you've still got Authorities 1 open, I can ask you to go to tab 22. It's the downside of having rearranged my own bundle. It's page 8, it's case of SXC, page 802 of the bundle, and the relevant passage is at page 806. Mr. Justice Swift, at paragraph 11, says that the claim for compensation fails. And then at paragraph 12, he says, in some circumstances, a claim under the Human Rights Act is a vehicle to vindicate rights equivalent to those recognised in private law. The circumstances of Al-Saran and D are examples of such a situation. In such instances, compensation may be the primary, if not sole way in which just satisfaction can be afforded for the breach of convention rights. but the present claim is not of that nature. Rather than circumstances of this claim are a classic example of an instance where the Human Rights Act is relied on for the purposes of a purely public law challenge. So that comparison with tort being made. And then that reference to Al-Saran is to the judgment which you find at tab 38 at the end of volume 2. It starts at 1306, but can I ask you to turn in the bundle to 1326? To say this judgment is a magnum opus, and by agreement we've only put in some extracts from
I've seen this done before. I think it's a rare exception to the rule. We don't mind not seeing the whole authority.
Yes, and our noble learned friend has done it again in Lumber, which also falls into that category.
Yes, I think that's allowed.
So paragraph 930, Mr. Justice Leggett cited Greenfield and Sternum. And then at 933, he looks at the question of whether damage should be awarded in present cases. Cites Greenfield, and then that's the internal citation of Annie Freover, which I took you to in the skeleton argument. And then just below letter B, there's the reference to the observation about many cases being in order to compel a public body to take or refrain from taking action or to quash an administrative decision of a public body. There are other cases, however, where the claimant is not seeking an essentially public law remedy of this kind, and which fall into the category described by Law Justice laws as cases where the violation of the convention right has an outcome for the claimant which constitutes or is akin to a private wrong. And that was then applied to open the door to a grant of an award of damages in that case.
So, none of the cases you've shown us, possibly SXC, which I'm afraid I didn't grapple with the facts, are cases of where, as a result of the discrimination or breach of the convention right, a payment that would otherwise have been made, I know you say it isn't the case here, but would otherwise be made, has not been made. Now that may not be analogous to a tort, but it is analogous to a private law right, namely a right to be paid money that you're entitled to as of law. So are these dicta particularly helpful unless they're applied in a case like this?
SXC, so just turning to the scenario of SXC, was a case involving migration to universal credit. Some people were paid, some people who migrated were being paid less than other people who had migrated, because some people got a top-up payment and others didn't.
Yes, I see. So,
yes.
I mean, obviously, all sorts of differences, but it's the same sort of claim. It's about not getting a payment to which you say you're entitled.
The purpose and the point of these cases is that the reference from higher authority of looking to see something that's analogous to a public law wrong, it chimes with that dictum about looking, in M, Lord Justice Sedley's dictum, has a discrimination done any harm, done the claimant any harm? Because that is, in many ways, the essence of a private law tort.
Yes. I'm bound to say that and the earlier cases seem to give the gist of the point rather better than saying it's got to be something that would otherwise be a tort or equivalent to a tort. I speak for myself, although apparently SXC goes differently. I would have thought that it would be enough if it was a private law, analogous to a private law right to a payment of which you are deprived.
Yes, but that wouldn't be a tort. the reason,
know.
the reason
That's
for
why
drawing
I'm saying-
attention to this is that the cases appear to be looking at, is there something akin to a tort? And the thing about a tort is that you get damages if somebody has done you a wrong, somebody's done you harm. And that goes back
It's
to...
a wrong not to pay you money. It's a wrong, though possibly not a tort, not to pay you money to which you're entitled.
Yes, it would be a wrong, but the essence of a tort is, has somebody done you harm, and did you get damages for the harm that you've been done? And that's all of a piece with Lord Justice Sedley's dictum. Has a discrimination done you any harm?
But the discrimination is the tort. That's the statutory tort.
So, yes. These are not precise analogies. I entirely accept that. But when you're looking at pointers to the sorts of situations where an award of damages would be necessary and others in which they are not, these are the kinds of things which come into play and the factors that are relevant.
But it's slightly different from some of the dicta you've just referred us to, I think, because in this case, I don't think the victims were particularly interested in having anything quashed or anything of that nature. They weren't really interested in a public law remedy.
Yes, although I don't think I would necessarily place emphasis on that. The question should always be, we respectfully say, has the discrimination done any harm? Has the claimant suffered a loss for which it is necessary to compensate by way of damages? And I'm now going to come on to make factual submissions based on the context of this case as to why in this case it isn't necessary when you've seen all the principles that have been talked about. So those submissions are as follows. Starting from the judge's findings, which we respectfully say is where one ought to start, these respondents were receiving exactly what the Secretary of State rationally and lawfully considered that they should be receiving. They were not being deprived of anything to which they were legally entitled. Let's say entitled, but for the present argument. The only problem was that there was another group who were accidentally being paid too much. And it's now, the court can see, uncertain as to whether or not it can, the proper analysis to say the Secretary of State's paying them too much or whether the DWP is paying them too much. That is a situation which clearly needs to be rectified. But there are good arguments for the Secretary of State doing this as part of a wider reform of the trafficking support system, which I think the court knows has generated an enormous amount of litigation. And as a consequence of all of that, it is not necessary to pay damages to the respondents for what has happened. We also say...
Can you just help me with this? Is it logically necessary to your argument that you are in fact seeking to rectify the error? I can see it's evidentially necessary. If you said, oh, it was a mistake, it was a mistake. And they said, well, if it was a mistake, presumably you're trying to put it right, and said, no, we're going to live with it. It would might raise some eyebrows as to whether it really was a mistake. But that's an evidential point.
But wouldn't it then become analogous to a legal entitlement, and then you would be into proper unlawful discrimination if you decided not to do anything about it?
Hypothetically, if that were the case, then another claimant might be able to construct an argument along those lines. I can see that. But that's not the case here. We have said from the outset, we intend to fix this. But there are lots of things in the trafficking support system that need fixing. And so what we're going to do is to replace the current system with one that is built on an entirely new foundation. That's to say, everybody gets a needs-based.
Does Miss Tan go that far in her witness statement? But I'm not saying she doesn't. I just can't remember about the plans to fix it.
Yes, we'll dig out the references. But yes, the plan to fix it is to replace the current system with a needs-based system so that everybody gets what they are assessed to need. But it's inevitable that that is going to be a more complex change than simply redrafting small parts of
The reason I'm probing on this is the judge obviously thought it necessary to say something about whether you moved fast enough. And I just want to see where that fitted into the argument. Why do you need to prove that you moved at a particular degree of haste or not? Is its relevance only to the fact that it was a mistake? And the fact that you take 2 years, say, to fix a mistake that you could have fixed in one, suppose that were the finding, it would still be a mistake.
Yes, and if that sort of argument were run, then we would say it doesn't take away from the fact that it's a mistake. If we had evinced no intention of changing it at all, then I accept the point could be made against me that actually this isn't a mistake at all. This was an entirely intentional difference in treatment.
Or I suppose it might have started as a mistake, but you've, as it were, adopted it by not doing anything about it.
Yes.
Yeah.
Yes. Yes. That's not the situation here.
And so you say that in the light of the evidence that you are intending to fix it, the amount of time that it might take and the judge's reference, therefore, I think to 7 to 9 months, is irrelevant.
Strictly speaking, it's irrelevant unless it goes for an unreasonably prolonged period of time. But one also has to bear in mind.
Well, hang on, but no. Why would that be relevant?
Because adverse inferences might be drawn.
Well, exactly. It would be relevant because a time would come when you've been not getting on with it for so long that your statement that it was never intended in the first place ceases to be credible.
And can I also turn this round the other way? There are situations in which a court might be very interested indeed as to exactly how long it's going to take. And that is if there is some discrimination which does cause a loss to individuals, but it is going to be fixed, and the Secretary of State says this is going to be fixed rapidly because we can't have a situation where people are losing out. And then it doesn't happen. And in that situation, a court might look at the question of timescale in a much more intrusive way. But here we've got the opposite context. Some people are being accidentally paid too much money, but nobody's losing out.
Is this a paraphrase of what you were saying? That where you are relying on the fact that fixing a mistake, you're going to fix a mistake as a justification, direct or indirect, or equivalently, if there's a rationality attack, you say, well, this came up unexpectedly, we know it's gone wrong, but we're trying to fix it. Then part of your defense might have to be that we're fixing it as fast as we possibly can. But this is a different context here, past the justification stage.
That's right, and this is looking at the question of whether the payment of damages is necessary. And I mean, if there were something in our conduct which gives the court reason to think that the explanation of mistake or anomaly is to be disbelieved, then these timing points might well go towards that. I should also say this while I'm addressing the question of what can be done to fix the problem. Doing the wholesale reform that is underway now would not have been the only way of fixing this particular problem. But one of the difficulties here is the squidgy jelly, of course. And if we had tried, we, the Home Office, had tried to fix our individual problem by doing something just to the trafficking support policy, it would run the risk inevitably of it throwing up some different problem somewhere else. And so if there is anything to which the time scale for a wholesale reform is relevant, it is also relevant to bear in mind that the other potential fixes are not without potential problems themselves. The second point in my submissions is this. It's clear, we say from the context, that if this accidental discrimination had not occurred, Group 2 victims, like the respondents, would still have received exactly what they have been receiving. And therefore, it is precisely the sort of case in which the overpayment to Group 3 can be described as an unjustified anomaly. That is, we respectfully say, properly regarded as a form of maladministration, paying somebody too much. But what it isn't is anything akin to a tort which has caused harm to the respondents. Because if there had been no discrimination, then they would still have been getting what they've been getting. Group 1 victims would have been getting what they were getting, and Group 3 victims would not have had the windfall.
But it can still be a tort, but nonetheless the harm that the no harm flows.
Well,
no.
technically, the discrimination, of course, it is a statutory cause of action.
But the discrimination hasn't caused them to receive less. It's caused another group
That's right.
unjustifiably
Yes.
and wrongly to receive more. That's your argument.
Yes, that's right. And so if one looks at not statutory torts, but the classic common law torts, which are all based on have you done some harm to somebody else, it isn't of that nature. And that's the point of looking at those dicta from Sternum and that philosophy of has a discrimination done any harm. So there's nothing akin to that, and there is no necessity to pay damages. And the third point is this, that if damages were payable to these respondents, they would have the unjustified windfall would end up having to be paid to everybody, because there is no proper distinction with other Group 2s, and then once you're paying extra money to Group 2s, you couldn't not pay them to Group 1s for the same reason. So that is another reason why it's unnecessary. In that, there is always that the point made by Lord Brown and Wilkinson that there's no free lunch here. Paying
Lord Brown, not Lord Brown.
Sorry,
No,
Lord Brown in Wilkinson.
Sorry, yes.
Lord Brown in Wilkinson said that basically there's no free lunch.
You've got to look at the general body of taxpayers.
That's right,
and how they
taxpayers. Yeah, taxpayers will end up paying this, and there is no necessity to make taxpayers pay everybody an unjustified windfall. In the judge's judgment, he listed a number of reasons for the award of damages. Can I ask to go through these and make some submissions about them? It's a passage starting really at paragraph 125. It's core bundle page 120. 126, he summarises the findings that he's made. The discrimination probably occurred by mistake. They received the amount the government intended them to receive. Others accidentally and fortuitously received more than the government intended in the form of an unmerited windfall. So far, so good. But then at 127, one of the points he takes into account is that the treatment of the claimants has been egregious, the last few words of paragraph 127. We respectfully take issue with that if that was intended to be directed at the Secretary of State. The Secretary of State's made a mistake. That's not egregious treatment.
Well, where's this concept of egregiousness come from? Have I missed it? Is it in the case law somewhere as a test of the circumstances in which?
I don't know whether he was using that as a technical concept,
Well, it's a
or
word
whether
that-
he was just describing the treatment that the claimants, the respondents.
One of those words I wouldn't dream suggesting Mr. Butler did this in his submissions, but it's one of those words that counsel sometimes lay on to up the emotional ante, but I don't quite see what its legal relevance is.
Well, with respect, neither do we. One thing I would say is that if the judge was intending to describe the respondents' treatments at the hands of the traffickers, that might well be entirely justified.
It's irrelevant.
But it's irrelevant for these purposes, and he should not have taken it into account in relation to damages. The second point really comes from 128. He seems to be taking into account that the respondents were vulnerable people. But we respectfully say that also is irrelevant. The fact that they're vulnerable doesn't itself amount to any reason for just handing unjustified money out from the taxpayer's pocket. The third point, also, it comes from a combination of paragraphs 128, 130, and 133. He says, the last sentence, 128, he says, the respondents have, in a real sense, been deprived of an entitlement because they are asylum seekers, as well as being victims of trafficking. Now, it is true that the Group 3 victims who get the extra money are not asylum seekers. But Group 1 victims are also not asylum seekers. But they get exactly the same as the respondents get. And indeed, if the respondents were not asylum seekers who hadn't applied for asylum support or whatever, they'd still be getting the same amount. It would all come from the trafficking system and not partly from asylum support. And so that comment from the judge, or that observation by the judge, is with respect entirely wrong.
It doesn't sit well with the findings in 126 that they've received the amount to which they're entitled, and another group has accidentally received an amount to which they shouldn't have received.
We respectfully agree with that. And you see that same mistake made in 130. He refers to the amounts of money that would have been paid to these victims if they had not also been asylum seekers, which is simply not right. And you see the same phrase used again at 133. You can see that in this last section of the judgment where he's dealing with damages, that these points played quite a large role in his decision that damages were necessary. But with respect to him, these are without foundation at all. And given the thrust of everything else in the authorities and that flows logically from his findings at 126, the only conclusion he could properly have reached was that damages were not necessary in this case, either pecuniary or non-pecuniary.
There could be a different argument in relation to a non-pecuniary award if there was some evidence of particular distress at the difference in treatment.
I accept that, yes.
But there wasn't any evidence of that.
No evidence.
These victims of trafficking just wanted I don't say that pejoratively, but they were destitute and they wanted more money.
Yes.
It wasn't about feeling distressed at the difference in treatment.
Exactly so. Exactly so. Yes. So those are our arguments on ground one. But as my learned friend has set out very clearly the heads of the argument that he advances on ground one, can I turn to answering them perhaps at this stage, insofar as we understand them? First of all, we do make the point, I don't need to labour this, that the judge's findings of fact are about what happened, are not findings that this court should interfere with, given how firmly based they are in all the materials that I've taken you to already. Starting at paragraph 26, learned friend's skeleton argument sets out 6 arguments, which learned friend deploys to support the judge's finding. It'll probably be easiest actually if I ask you to turn up that learned friend skeleton argument. Starting, it's page 8 of the skeleton argument, it's core bundle page 48, if that's where you're working. 48. Core bundle page 48, paragraph 26 is the first one. Learned friend refers to a back payment scheme when that was set up when the Secretary of State discovered that there were payments being made to victims of trafficking who are in receipt of mainstream benefits that fell short of what the policy required. This comes from a paragraph in Ms. Tan's witness statement, Secretary of State's witness statement. And I think it's probably easiest and best if I ask you to look at that paragraph first. It's in Supplementary 2, page 16, and it's paragraph 19 of the witness statement. What Ms. Tan says is that we are aware that prior to November 2019, some individuals may have received...
Sorry, Mr. Tan, I've taken too long. What page did you say?
It's page 16, Supplementary 2, and bottom of that page, paragraph 19. Some individuals may have received reduced financial support payments as a result of receiving alternative sources of income in a way that was not in line with published policy or with the wording of the contract. This indicates that while there was no published policy to do so, the contract was operated in a way that prevented duplication of payments being received from other government support. We are in the process of establishing a program of back payments where appropriate to individuals affected by this practice. So it's clear from that what happened was that, contrary to policy, somebody had decided that there shouldn't be a duplication of payments.
Sorry, there should or shouldn't?
There shouldn't be duplication of payments. And so some reductions to eliminate duplication were being made contrary to policy. And that's what the back payments were about.
Well, that's rather opaque.
It
People
is.
receiving mainstream benefits.
Well, this is the point. This was not a central issue in the case. This is the evidence that the judge had. Learned Friend's skeleton argument tries to whip this up into something which is much more than it is. Because the way that he puts it in the skeleton argument is that the Secretary of State discovered that she had not, in fact, been making these child-dependent payments to Group 3 victims. We don't know whether or not that is what this is referring to, or whether it's the totality of the potential problem. Neither do we know whether it covers the entire cohort of Group 3 victims of trafficking with dependent children. And so the way that Learned Friend puts it in the skeleton argument is with respect.
You're saying this wasn't explored before the judge, are you? and there's nothing in the judgment about it.
Well, the judge did make a passing reference to it, but not in any detail. I'll ask Leonard Jr. to try and find the paragraph number of that.
But your point is there's nothing here to build anything on.
There's nothing here to build anything on, but certainly what there isn't is any suggestion that we have deliberately decided to act contrary to our case that there was an anomaly and a mistake. The point here about these payments being referred to at paragraph 19 is that if the payments were reduced, they were reduced contrary to policy. And so back payments are there to restore people to the position in which they would have been in if policy had been followed. Otherwise, they would have had an obvious complaint to make about what they received. It's got nothing to do with the present situation where the respondents are getting exactly what the policy provides and what the policy rationally and lawfully provides that they should get. And so there is actually nothing in this point, even in the way that it's been put in Learned Friend's scope argument. The second point that Learned Friend make, this is paragraph 27 of the skeleton argument, it's about the replacement scheme. I think I've probably made all the submissions that I can usefully make about that. What we say is that this paragraph of the skeleton argument misses the point. The real point here is whether the differential treatment was targeting Group 2 victims of trafficking at all. Were they being deprived of anything? But I've made my submissions on that, so I'm not going to repeat those. The third point is that if the new scheme had already been in place, then the respondents probably would, Learned Friend says, have received the payments equivalent to what's in issue in this case. Would have received those payments because they need payments to meet their trafficking-related needs. The first thing that we say about that is, of course, that's not what the payments are for. The payments in issue in this case, they're for essential living needs. So this is actually shooting at the wrong target altogether. But second, looking at what the new scheme might provide is not the question in issue. The question is, if the discrimination that occurred had not occurred, if the mistake had not occurred, what would have happened? And for reasons I've already submitted, it's quite clear that that the respondents would still have been paid exactly what they were being paid. The mistake, if it had not been made, would have meant that Group 3 was not being overpaid, as in fact they have been. The fourth point refers to the needs that the respondents have because of the experiences they've undergone. Now, it's no part of my case to try to minimise or downplay what they have undergone. We all know how awful human trafficking cases can be. But for the legal purposes of this appeal, those might all be arguments why the respondents should be paid more than what the policy provides that they should be paid. But the thing is, the judge looked at the policy and said, well, this is a Secretary of State's choice and it's rational and it's lawful. And so these arguments really don't take the case any further. They're certainly not a reason for the judge, for upholding the judge's decision. The fifth point is one, this is paragraph 31, is that learned friend says it's a targeted denial case. But again, I've made my submissions already about why that's not what the problem has been here. They're not being deprived of anything that they should have got. And finally, there's a reference to the numbers of individuals. And the way in which learned friend puts it is how I've got to the estimate of several hundred group 2 victims who have dependent children. What we were not able to provide the judge with was any evidence about how many group 3 victims with dependent children that there are, by way of comparison. We have since found that out, and if it would help the court to know, the order of magnitude is several dozen at any one time. So this is not the sort of case where 99 people get too much and there's one person, the one complainant, who's getting what the policy says, but says, hey, I'm being treated unfairly.
Well, I can't leave the case to turn on this, but your figures just don't. Are they the same sorts of figures? You say several dozen at any one time.
Yes. The thing is, of course, the groups change. People come in and go out.
I understand that, but if you take a snapshot today,
yeah.
you say there are several dozen group 3 individuals with dependent children. Okay. How does that compare with the figure of 1,671? Is that also a snapshot?
No, the 1671 is group 2 victims.
Oh, sorry. Yes. Okay. Let's okay, a quarter. So let's say 400.
Yeah. So
are those 400 a snapshot at any one time?
Yes, those are also snapshot figures, and also the estimate of a quarter actually dates from a completely different point of time. I think it's a 2012 estimate, but it doesn't really matter because we can only really look at orders of magnitude, but that's what it looks like.
Your real point is that it's not a case where the vast majority are in group 3 and a very small number are in group 2.
Exactly. So that's what we say at this stage about the 6 arguments in Learned Friend's skeleton argument on the main case. He then turns to an alternative analysis, as he puts it, which is basically an attempt to resurrect the respondent's factual case before the judge below. I've made my submissions as to why that is an attempt which should not be entertained. But starting at paragraph 38, there are 4 points that Learned Friend makes on this, which I think I can usefully respond briefly to now. The first point that he makes is that the trafficking support scheme is not means tested, and that as he puts it, the only carve-out from the trafficking support scheme related to those in receipt of asylum support. A very quick answer to that, which I've already shown you, not a carve-out at all. It's a routing provision, and so this argument doesn't work. The second point that he makes is that the victims of trafficking themselves also get payments that reflect the same problem. And this is why, in answer to the court earlier, I thought it would be helpful to acknowledge that at the outset. Yes, there is a potential problem. It's not part of this case, but the problem is of exactly the same nature, that there's been a fault in the way the policy has been drafted that leads to the individual receiving essential living needs payments twice, once from the Home Office, once from the DWP. The third point he makes is that that universal credit started a long time ago and predated the current policy, and therefore the explanation that we've given should not have been accepted by the judge. As a matter of history, universal credit may have started in 2013, but it's been a very gradual process getting that across. Indeed, as I understand it, it's still, the rollout is still not complete now, and so there are still people who are on legacy benefits. And given that it's a completely different department's project, there's nothing that can be inferred from the fact that the policy was drafted by the Home Office in these terms, dealing with trafficking support. But in any event, the key question is always, what are these payments intended to cover? And whatever the history of universal credit doesn't change the answer to that question. The amounts of the payments and the history of those demonstrates that the payments, the 3960 payments, are for essential living needs and not for anything else. And the fourth point refers back to evidence that we adduced about the child payments having originally been set at at levels matching child benefit rather than child asylum support. And what Learner Friend says is, well, if it's child benefit, that can't be for essential living needs, and therefore the current 3960 can't be for essential living needs either. We say, first of all, most importantly, if you look at what the position is now, it clearly must be right now. But even in relation to child benefit, clearly it doesn't cover the full costs because it's lower than essential living needs. But the two cases that Learner Friend cites that deal specifically with child benefit recognise that child benefit contributes towards those essential costs. So if you look at paragraph 41.1 of the skeleton argument, Learner Friend's skeleton argument, the quotation from Ford, the contribution towards the costs incurred by every family in bringing up children, and in PO, in the last underlined sentence, child benefit is not intended by itself to meet financial costs. It couldn't have met all essential living needs, but clearly it is money that was intended to go towards that as recognised by those authorities. So there's nothing in that point either. Before leaving ground one, I should say something about non-pecuniary loss specifically as a different topic from the pecuniary loss claim. My Lady Justice Simler put to me the point about the evidence, about the evidence from the respondents. The complaints are, as we've set out in our skeleton argument, the complaints that they make are, we could really do with more money because we have these needs that are not being met, and not having the money makes it very difficult for us to go to our recovery appointments and sessions. Well, that may be all very understandable, but there's not a breath in any of their evidence that they have been distressed or humiliated or embarrassed by the fact that somebody else is accidentally getting more money than they are. There's simply nothing in the evidence about that at all. And without that evidential foundation, we respectfully say that there isn't a proper case for awarding non-pecuniary damages for a breach of Article 14. As part of Learner Friend's argument, or intended argument on this, he's produced a table of Strasbourg cases, which I hope has reached the court. And he kindly invited us to look at the draft table to see if there was anything we disagreed with. There's nothing that we positively disagree with in the way that's been summarised. So we haven't tried to produce another version of that for today's purposes. Obviously, there are things that can be said about the facts of individual cases, if necessary. But I think that there are two overarching submissions which are probably all I need to say about that. The first is that those were all cases in which each applicant was clearly discriminated against. That is to say, they suffered by not having something or being treated more badly than they should have been, and so on. So, or classic discrimination against the individual where they'd lost something. And those are the cases that have been listed. None of those are going to help here, because this is a case about somebody who hasn't lost anything, who's getting paid what she should be getting paid, that's the rationally and lawfully getting paid the same amount as Group 1 victims, and somebody who has produced no evidence of being humiliated, embarrassed, distressed in any way by the difference in treatment, rather than simply not having as much money from the state as she thinks she ought to get, or she needs for her own needs. So none of these cases is actually on point at all. What is going to help is looking at the cases dealing with the principle of what you do about damages in a situation like this. Those are the ones I've been through already, both domestic and Van Raalte case in Strasbourg. But the second overarching submission about this table is this. The table and the cases cited in it tell you nothing at all about the cases where, or about the circumstances in which the Strasbourg court does not award damages for non-pecuniary loss. It's been filtered so that these are all cases where awards have been made. What would assist the court is the similar exercise being done of cases in which awards have not been made, to try to understand why the Strasbourg court thought it was not necessary. We've rested our argument on the basis of high authority on principles applied to what we say is a very clear case. Unless the court thinks it would be useful for us to embark on this exercise of looking at cases of non-awards, we would rest on the application of the principles that are...
When you say non-awarded, you mean claimed but refused?
That's right.
Yes.
Yeah. So the Van Raalte type of case, but looking at the recent decisions from the court of that nature.
Well, certainly not an instant response to that possible non-invitation. We'll see where we go about that.
So it may be that I'll have to come back to some of these points in reply, but I hope it assists to set out our stall like this, and Learned Friend knows where we're heading on that. So that's ground one. Can I then turn and perhaps make a start on grounds 2 and 3? Because I think I can deal with one point of principle before the short adjournment. I've already outlined that, that our first heading is that the discrimination can't be both direct and indirect at the same time. And it's quite clear that what's being complained of here is the same conduct. That's to say, overpaying Group 3 when Group 2 is not...
Well, I've been thinking about that. It's absolutely trite law domestically, and there may well be Strasbourg authority as well. There probably isn't actually Strasbourg authority because they don't tend to distinguish as clearly as we do between direct and indirect. There's certainly plenty of domestic and Luxembourg authority that it's got to be one or the other. But isn't that always in the context of a particular ground? A particular measure cannot be both directly and indirectly discriminatory against on a particular basis, say against on the basis of gender or on the basis of race. I can't see anything conceptually wrong in something which is directly discriminatory against women, say, also being indirectly discriminatory against a particular racial minority. I'm not very good at thinking up examples, but in principle one could think of some characteristic of women which was also more common or less common for a racial minority or a particular racial minority. But aren't all the authoritative dicta about strongly one or the other aimed at that? And if that is the case, that's not what's being said here. You've got, on the one hand, direct discrimination against, to put it shortly, asylum seekers, and indirect discrimination against women. Sorry, I probably should have let you show me the authorities first and then say what I thought.
But we base this on primarily on Cole in the Supreme Court.
You may show us Cole, and it may show what I just said is nonsense.
It's Authorities Volume 1, Tab 18. The first thing I think to draw attention to is paragraphs 30 and 31. So this is page 591 of the bundle. The court probably knows that the background to this is approved premises, and there were fewer for women, and so they ended up typically being further away from home. Paragraph 30, Lady Hale refers to the Birmingham case. Some of the girls achieved a high enough pass mark to gain place at selected schools. What all the girls suffered from was the risk that if they did not get a high enough mark, they would not get a place. In 4 lines up from the end of that paragraph, in the Birmingham case, some of the girls did, of course, achieve a high enough mark, but there were some who achieved a mark which would have been high enough had they been boys, but was not high enough because they were girls. This is direct discrimination on grounds of sex. I can see no valid distinction between the Birmingham case and this case. In this case, all the women who would be required to live in an AP when released on licence suffered the much greater risk than the men that they would be sent to an AP far from their homes and families. The fact that some of them would not suffer this detriment does not mean that those who do suffer it have not been discriminated against. So that's the nature of the discrimination which was found. It's direct discrimination. And then at paragraph 43, Lady Hale goes on then to deal with indirect discrimination. 43, Ms. Rose accepts it is difficult to analyse this case in terms of indirect discrimination. The whole point of indirect discrimination is that a PC plea applies equally to, in this case, men and women, whereas the complaint here is of unequal provision. Shoehorning the complaint into indirect discrimination by identifying the PCP as a requirement to live in an AP on release on licence does not really work, because what has to be justified is the PCP, and such a PCP is readily justifiable by the aims of protecting the public, reducing reoffending and assisting the offender's rehabilitation. In my view, no such shoehorning is required. Conduct cannot at one and the same time be both direct and indirect discrimination. The finding that this is direct discrimination, albeit potentially justifiable, rules out a finding of indirect discrimination. Now, as I've been reading that, I've been pondering my Lord's question, because I think that the claim would have been indirect discrimination also on the grounds of sex.
I think so.
And so that is what was there.
You've got lunch to think about it.
Yes, if that would be a convenient moment.
Well, I think it probably would. I mean, if you're a 1 minute case, we'll look at that. But where are you going next?
No, I was going to look at 2 which go together, which will take more than 1 minute.
Well, no, let's pause there. You reasonably confident you're going to get there by 3? I thought you probably
yes.
Yes, I thought so too.
Well, before you rise, you asked a question about the asylum support scheme. Might I hand up an authority which conveniently sets that out, or I can wait till later?
Okay, I don't promise to read it over lunch.
No. And I think it answers my Lord's questions about that scheme. It's particularly paragraphs 11 through to 19.
Thank you.
11 to 19. Okay.
You've got, I think, the second one.
But I'm afraid I'm not going to, even if it answers all the questions, I still think we need the actual relevant statutory provisions.
Nordics.
Okay.